Welcome everybody to Facebook Live today, and for those of you who know me, my name is Roger Levitt and I'm a business and property mediator. For those of you who don't know me, I'm still Roger Levitt and I'm still a business and property mediator. Today I'm going to be focusing on what happens when your business partnership goes sour for any reason. So for those of you who are involved in a business with other people, this will apply particularly to you. For those of you who run your business entirely on your own, then I'm sure that there will be other people that you'll know who are affected by these issues from time to time. Now, I appreciate that this is a very, very sensitive subject, and if you have any questions, I would be really grateful to receive them. Those will probably be questions of a general nature. If you have any specific questions you wish to ask me, feel free to contact me separately via the directory or at roger@rogerlevittmediation.co.uk. So you set up a business with somebody else. We would commonly call you co-founders. And what happens if it goes wrong? Now, of course, there are many issues that are routine and are dealt with in everyday discussions, and those aren't the sort of problems that we're talking about here. We're talking here about larger issues where the very nature of the business is affected. Disputes happen between co-founders in a number of ways, a number of reasons. For example, if the business is failing and each person is blaming the other, obviously that's not good. But when you get to the point where it's gone past how it can be remedied, then that needs to be addressed. Another reason is if personnel, accounts, strategy, or future direction can't be agreed. Now, that clearly is fundamental. And again, we need to find a way of addressing and dealing with that. If the business is succeeding, it may be that you're fighting over the profits for whatever reason, either because the percentage shares are no longer applicable as far as one or both of you are concerned, but it may just be that you're both being greedy, and again that needs to be addressed. Another possibility is that the co-founders have simply grown apart or can't stand working with each other anymore. However tough that might appear to be, it still is something that needs to be grasped and dealt with. And the last example that I'm going to mention here is if retirement is nearing and terms can't be agreed. So one party wishes to step back from the business, and you can't agree between you how that should best be done. So what happens next? The key is to act quickly and professionally and without confrontation to nip the dispute in the bud. Now, of course, that's much easier said than done. The longer the dispute is left to fester, the worse the problem becomes, and the more costly it will to be resolved. And of course, in both time, stress, uncertainty, and the cost of doing so will quickly escalate. So in my experience, most people who come to me for mediating a dispute do so once the dispute has gathered a head of steam, because I think human nature is such that people think, well, it will go away. if we ignore it or if we carry on working, it'll all resolve itself. And so what that means in practice is that people often come to me when they're either just at the point of issuing proceedings, or they have already issued proceedings. Now, if it is possible to think about a situation where you can stand back and act before that happens, it will save so much time, money, stress, and uncertainty. And that's the trick, that's the challenge, because a small business can be very much like a marriage. A 2016 government survey found that more than half of all small and medium-sized enterprises have only 2 partners or directors. What this means is that the co-founders often appear and work as if they're married to each other. The business and personal lives can be interlinked, and sometimes that works fantastically well, but other times, sadly, it doesn't. So if and when it starts to go wrong, because either or both of you want more or less than there was there at the beginning, or maybe just the novelty has worn off, it's necessary, like a failing marriage, to grasp the nettle and work together at a managed exit. So making the decision to mediate. Making a big decision to mediate is a brave step. Rather than put your heads in the sand and hope it'll go away, or worse still, taking an adversarial and confrontational positions, which in time would lead to litigation. So well-advised co-founders will have had a shareholders or partnership agreement drawn up before the start of the business, and if it's well drafted, it will have covered most situations that could come up, including having a dispute resolution procedure, which often provides for mediation. But even if an agreement doesn't specifically provide for mediation, it's always an option, because mediation is a voluntary process where people enter into negotiations through the independent mediator. The mediator will guide the process, will have either joint meetings to start with, or if the parties won't sit together at all, then the parties will sit in separate rooms and the mediator will shuttle between the two. So in my experience, a negotiated, managed exit is likely to prove the best outcome, and ideally to help preserve the co-founders' relationship, which in time may be healed. And if litigation is the route that is taken, it's very likely that relationship will be lost. And this is a really key point, because often business partners will have known each other for many years. It's a terribly sad thing if the business does flounder, but it's not always the case that should mean that when you've gone your separate ways, you should lose the relationship that you had for those number of years. So mediation is private and confidential. It can help to facilitate a settlement between parties in a way that litigation doesn't offer in the same way, because of the flexibility of mediation, because of the informality, but also because of the confidentiality. It means that any agreement that you come to in the mediation will remain confidential, assuming that that's what you want to happen. That'll be one of the main terms of the settlement agreement. And the advantage of mediation is that in negotiating a settlement through the mediator, you have the control of the negotiations, in as much as you can leave at any time, you can pause, you can park everything that you have agreed and come back to it at a later time, and that will still retain the confidentiality that was a key point of the mediation. And you don't have that flexibility in a litigation. The litigation will be about whatever it is that's pleaded in the litigation, and the court and the judge will only be able to look at the matters that are pleaded in the proceedings itself. Mediation has the flexibility of being able to produce a much wider solution. You can bring in factors, you can bring in issues, you can bring in possible solutions that you wouldn't be able to do in a litigation. And of course, one of the big advantages that mediation has over litigation is that in mediation you can both achieve a resolution. You can both get something out of it. In litigation, there's one winner and one loser. So one of the parties is going to feel cheated. One of the parties is going to be unhappy. In a mediation, the cliche is that it's a win-win situation. Well, it's a very nice way of putting it. I usually describe it as slightly differently, that each party has lost equally, because when you're talking about breaking up a business or changing the ownership of the business, it's never going to be the same as it was when the two co-founders got together in the first place. But each party will be satisfied to the extent that they have got something, and I would say equally, but they will in real terms be equal losers. But a big plus, if it's able to be achieved, is that the relationship can be preserved, and that's an absolute key to any breaking up, whether it's a marriage or whether it's a business partnership, can be hugely emotive, hugely difficult for everyone concerned. And if you can make it as amicable as possible, then at least that limits the amount of pain that's being suffered. So the situation where a set of co-partners, co-founders can work their way through and manage the exit or manage the restructuring of the business through an independent third party is absolutely the goal. And I would say that anything is possible with the right will on both sides. If one party is determined for there not to be a good settlement, then obviously that makes things so much harder. But if each party can be realistic, pragmatic, non-emotive, putting your emotions to one side is terribly difficult if you're caught right in the middle of it. But if you can do that, then you will be able to find a solution with the help of the mediator. And the role of the mediator is to act as a trusted independent person who has the ear of both sides, and that takes time to build up that trust. So what I always try and do wherever it's possible before a mediation is to have a separate meeting with each party, with their professional advisors, if that's also possible, and there I can talk through with each individual how the mediation process works, what you should expect, what you should not expect, what you should do in order to prepare for the mediation, and what questions you can provide answers to, which I set out in a briefing note, which I send out when I get instructed. And I find this is particularly helpful because it makes everything very clear to all the participants, and of course their advisors, who will probably have had experience with mediation, but nevertheless it does clarify not only what the procedure is, but also it gets you thinking in the right mindset. And the mindset is hugely important, because if you go into a mediation in the wrong mindset, thinking that this is preparing to go to trial, or thinking that this is a mini trial itself, then you're not going to get the most out of the mediation process. The mediation process requires a completely different mindset, and you're preparing for peace, and you're not preparing for war. And that's why I think it's so helpful to have these separate pre-mediation meetings with the parties beforehand, because it enables them to prepare to think in a different way. We're thinking about how we can work collaboratively together to get the best out of this situation, which is not a good situation. But if you work together, if you think together, obviously representing your own interests, but respecting the fact that there is another view, listening to the other party and understanding where they're coming from, it's usually the case that you can get more out of the situation. If you dig your heels in and just think about what I want, then the chances are that the other party is going to do exactly the same. If you can put yourself in the other person's shoes and think, how can I bring them to a situation where they can help me get what I would like, and I can also help them get what they would wish to have. And I can't help but keep coming back to the Brexit negotiations. It's quite astonishing the way the negotiations have gone between the parties in Parliament and the EU and the government. And to me, the situation cries out for mediation. It won't happen. And the reason that I know it won't happen is because I'm aware of some senior mediators having volunteered their services to the government, and they've been rejected. The government say we don't need it. Well, if ever there was a situation that really did need it, this is it. But here we are, less than 50 days from the 29th of March, and we're no closer. Well, maybe a tiny bit closer, but we don't appear to be anywhere near close enough. So to use that analogy, and to just go back to refresh what I was saying about how it's very important to put yourself in the other person's shoes. And clearly, it seems to me that the politicians are not doing that. There are some on the margin. There are some, I would say, enlightened Conservative and Labour politicians who are prepared to reach across the divide. But to use that analogy in the shareholders, co-founders situation, if you can stand back and look at the situation and try and detach yourself from the emotion of the situation, it's quite extraordinary how much extra can be achieved. And I can think of many examples where that has been the case, where at the beginning it looked like all was lost, and then through positive, proactive, collaborative negotiations, an agreement has been reached. And when that's the case, it's extraordinarily rewarding for everyone, because from a situation which looked like it was never going to be retrieved to having outcomes where parties are actually hugging each other, because they've broken through the conflict and come out the other side. So I've had that in a number of cases, and it's extraordinary. As much as people can disagree, they also have the capacity to agree. So obviously the outcome that we're looking for, the aim, is to reach a settlement which both parties can live with and move on with their lives. This will either be separately if they decide that the business needs to be split, or we shouldn't ignore the possibility that through mediation discussions, it could be that the parties find a way of continuing the business as partners still, but maybe in a slightly different form, maybe with adjusted legal arrangements, different expectations, and those can all be incorporated into a settlement agreement or a memorandum of understanding. And so the aim at the end of the mediation is to sign up to an agreement which works for everybody. And then, obviously, as I mentioned earlier, assuming that it's a confidential arrangement, then only the parties and their legal advisors will know anything about what has happened. And so that means that people that the business contract with, customers, clients, and staff need never know. So I always adhere to the principle that, or the wonderful quote that Churchill famously came out with, and that's that jaw is better than war. And if you can't talk to each other, please talk to me. So I'm delighted to answer any questions if anyone has any. Does anyone have any experience of disputes in this area that they would like to discuss? obviously on a no names basis. Or does anybody have any questions that it would be helpful to others to be able to talk about situations and experience? Okay, I can't see any questions coming up. But as I said earlier, if there's anything you want to talk to me about separately, please feel free to contact me either via the directory or at my email address, which is roger@rogerlevittmediation.co.uk, and I'd be more than happy to answer.